Welcome to iEnhance Advocate. iEnhance Advocate is a platform for lawyers having less than 5 years of practice to come here and deliver a lecture on the topic of their choice. Today we have with us Advocate Kunal Jagdish Motwani. He is a practicing advocate for over 3.5 years. Advocate Kunal has graduated his law from KC College in the year 2020, his LLM from KC College in the year 2022, which was in criminal law, his Masters of Business Law in the year 2020-24 from NLSIU Bangalore. Advocate Kunal is actively appearing before the Honorable Bombay High Court and various courts in the region of MMR. Today, he is going to speak on overview of Cheque Dishonour Offence. So without wasting further time, I would request Advocate Kunal to commence with his lecture. Thank you.
Greetings everyone. Today I will be discussing in a brief manner about the provisions relating to the offence of dishonour of checks which is given under the Negotiable Instruments Act. Now when we speak about negotiable instruments, they are basically instruments which are used for mercantile purposes, that is conducting businesses, dealings and transactions. Earlier, it was purely based on cash basis, but as businesses started flourishing, then they devised various modes for dealings in commercial transactions, which included negotiable instruments such as bills of exchange, checks, hundis and other such instruments. Now, check is basically a piece of paper whereby one person who's the maker of the check promises to make payment for the amount which is specified in that check to the payee who's named therein. Now, the provisions of regarding the check are given under the Negotiable Instruments Act. Now, when originally this Act, Negotiable Instruments Act 1881 was passed, there was no provision for dishonour of checks. This was brought in the year 1988 by an amendment regarding amendment of banking, financial and negotiable instruments. Now, this Act of 1988 was made effective from April of 1989. This chapter 17, which was added into the law books under the Negotiable Instruments Act, has as on date total of 13 provisions from section 138 onwards till section 148, where there are two other provisions which have been amended. Now when we see the overall scheme of this act, there have been multiple amendments which include the three major amendments: 2002, 2015 and 2018. Now when you see the Negotiable Instruments Act, there is a section which defines what is a negotiable instrument, but it is very exhaustive in nature. It does not expressly explain what are the contents and what exactly a negotiable instrument means. It says it includes bills of exchange, checks and other forms, but does not specifically define what is the mode of the instruments. Similarly, another provision is there defining the check, which by an amendment included an electronic check in a truncated format. Now, when you say about check, a check has three parties. One, the maker or the drawer is the person who makes the check, who puts his signature. Second is the drawee. Drawee is always the one which is a bank. The check is always drawn on a specified banker. And third is the payee, in whose favor the check is being made. So when you see a check, the first name which is given is the payee, in whose favor the drawer has made the check for the amount specified therein. Now, when it comes to the offence of dishonour of check, there are specifically two parties. One is the maker, who's the drawer of the check, who becomes an accused in the complaint, and one who's the payee or the holder of the check becomes the complainant. The object of bringing this amendment into the Negotiable Instruments Act of including a new chapter, chapter 17, was to instill the public's trust in the banking operations and also to punish the dishonest drawer of a check for the offense of dishonor. Now, the intention is primarily based as a deterrent effect rather than putting a person behind bars for recovery of the amount. So, there is a judgment of the Honorable Supreme Court of India where the Honorable Supreme Court has categorically stated that the offense of dishonor of check prescribed under section 138 of the NI Act is literally a criminal, is a civil sheep in a criminal wolf's clothing. This new special enactment which was brought in under the Negotiable Instruments Act by the inclusion of chapter 17 gives rise to a new offense. The right of recovery of money was still available even before this, but it was prevalent under the civil codes, whereas now because of the provisions contained in this chapter, the complainant has a right to launch criminal prosecution for recovery of money from the drawer who has defaulted in making the payment. Now, section 138, from the bare reading, one can extract and summarize that the check which has been made is for the purpose of discharging either in full or in part a debt or a liability which is legally enforceable. Now, what do you mean by this? That there has to be a relationship of a debtor and a creditor between the drawer of the check and the payee of the check, where the drawer has made promise to make payment to the payee or the holder of the check for the amount stated therein, which is arising out of a transaction between them. Now, the purpose of launching criminal prosecution is to get back the legally enforceable debt which the drawer owes to the complainant, a drawer, that is the accused, owes to the complainant payee or the holder, and this is very much essential for the purpose so that the proceedings under this act can commence. Now, 138 is a penal statute, is a penal provision which gives rise to a new form of a regulatory offense. Technically, there is mens rea which is already presumed in the favor which is against the accused, whereas there is no specific need to prove that. Now, when we say that the check was issued for the discharge of a legally enforceable debt, it will not include any checks issued for a gift purpose, charity purpose, or for a time barred debt, or for a future contingency. The debt which is for the purpose of which the check is issued should be in existence. Now, there is a proviso under this section which says that for the launching of criminal prosecution under this section, the complainant or the payee or the holder of the check has to give a statutory demand notice to the accused who is the drawer of the check. Now, this statutory demand notice must be in writing and must be communicated to him, where there has to be a specific demand made to make the payment of the amount which is mentioned in the check. Now, there are some times where the demand notice also adds on additional amounts, say for interest, for another fees or some other expenses. If those amounts are excluded from the express demand made for the check amount, then this notice is valid. Now, the main important purpose of giving this notice is to make a demand. If there is no demand, you are not calling upon the accused to make the payment, then that notice becomes ineffective. Giving of notice is like a final opportunity which is given to the accused to make good the loss which the complainant has suffered. Now, this notice states that there has to be a 15 days time limit for making the payment upon receipt of that notice. Now, this 138 provision is very time specific. The notice has to be issued within 30 days from getting the information about dishonor, and the period which is given to the accused for making payment is 15 days from the receipt of that notice. And this notice is the foundation for proceeding ahead in the launching of criminal proceedings under this section. Now, when we say that under Negotiable Instruments Act a person is being prosecuted, the cause of action for this is when the accused defaults in making the payment within the specified timeline, that is within 15 days of receiving the notice. Once the accused fails to make the payment within this timeline, the complainant within 1 calendar month has a right to launch criminal prosecution before appropriate courts. This section is an which recognizes an act of omission as an offence rather than a positive commission act. This section 138 is the primary basis for launching the prosecution against the offender for dishonor of check. Now, this 138 provision will not bar you from exercising other legal remedies which are available to the complainant under other specific laws. It may be under the Civil Procedure Code for the suits, regular suit, summary suit, or any other appropriate proceedings. It may be under any other special legislations for that matter. So, even from the same set of facts, there can be multiple proceedings, and that will not be a double jeopardy against that accused person, because the cause of action in this is non-payment even after making a demand. Now, when we say about section 138, I proceed to the immediate next section, that is section 139, which raises a statutory presumption in favor of the complainant. Now, this presumption is twofold. One, that the check was issued by the drawer, that is the accused, and second, that the purpose of issuing that check is for discharging of liability which is legally enforceable. Now, this presumption is a statutory presumption which the court is mandatory to follow. The words used is shall, not may, and it is a rebuttable presumption which the accused has a right to rebut by bringing in evidence on record to discharge this presumption, and this proof which he is bringing on record, the standard of such proof is not beyond reasonable doubt. It is preponderance of probabilities. Now, unless and until this presumption is not rebutted by the accused, the presumption is valid in the favor of the complainant. Now, moving on to the next section, that is section 140, which says that defense which may not be taken. The defense the accused may not take before the court that he was not aware that at the time of issuance of check, in the future when presented to the banker, it may get dishonored. He can't make such vague defenses to save himself from criminal prosecution under this section, under this act. Now, moving on to the immediate next provision, that is section 141. This section is a very important provision under the scheme of this act, whereby a vicarious liability is imposed on individual persons when the drawer of the check is a corporate entity which is a judicial body by itself. Now, that may include companies, firms, association of persons, trusts, or any other such legal entities which are corporate bodies, have juristic bodies which have their own separate presence in the eyes of law. Now, section 141 specifically holds persons who are in charge and responsible for the day-to-day activities or the business of the firm or the company. Now, this section imposes a liability on these individuals in their personal capacities because they work upon the actions of the accused company, firm, or other juristic person. Now, when we say that these liabilities imposed upon them on 141, it is very important to know that it has to be proven by the complainant that there was either some connivance between these persons or they were somewhere involved in the transaction. A person, the complainant, cannot make sweeping blanket averments in his complaint that this person was also involved. Now, this section specifically uses the terms as directors and partners to be held liable or any other persons. Now, when it comes to partners and directors, the partners who are actively involved in the transaction in running of the business, who despite receiving the notice have not taken positive step of repayment of the amount to the complainant, are held liable under this section. Now, for that purpose, there are judgments to say that non-executive directors, independent directors, sleeping partners who are not at all active in the business of the firm, who are mere representatives taken on the board of the firm or as a partner in the firm, cannot be vicariously held liable for this transaction. There are two important judgments on this specific section. One is SMS Pharmaceutical versus SMS Pharmaceuticals, and one is KK Ahuja. They both are Supreme Court, where they specifically mention and describe how an individual person can be held liable under 141 of this section, section 141 of this act for the purposes of the offence under section 138. Now, coming to the next provision, section 142, which deals with cognizance of the offence. Now, there are multiple important facets which are given under this section. One, this section prescribes that the complainant cannot initiate any proceedings without making a written complaint before the competent court having territorial jurisdiction. Now, the purpose of expressly using the word written complaint is to understand that it's a non-cognizable offence. There cannot be an FIR registered for the purpose of offence under section 138. It is a private criminal prosecution where the complainant is dragging the accused to the court for recovery of the amount, and there is no other investigating agency which is involved in this transaction. And it is not an offence against the state or public at large, it is a dispute between two individual parties. Now, secondly, this complaint which is to be filed before the court of a judicial magistrate of first class. It is very expressly written that the magistrate courts will be the appropriate forum for conducting the trial for this offence. Now, when we come under the new code, after filing of the complaint, there is a new provision under the BNSS which prescribes that before taking of cognizance, a pre-cognizance notice has to be issued to the accused person. Now, this is something new which is brought in by the new courts, which was not in existence when the earlier CRPC was in force. This concept is very alien to the regular people practicing on criminal side, because at the stage of cognizance, the magistrate has to simply apply his mind to the facts of the case, and then thereafter, after taking cognizance, issues process against the accused persons, and that accused persons did not have any say in this matter. Now, because of this new provision being brought under the BNSS, the accused, even before taking of cognizance, has a right to make representation before the court. Now, the provision also states that this complaint which is to be filed before the concerned JMFC court is to be filed within 1 calendar month upon the expiry of the period mentioned in the notice. So, after the notice is given, 15 days time limit is given to the accused person to make the payment to the complainant. Once that 15 days period expires, on the immediate next day, the period for filing of the complaint start as the cause of action has arisen on that day. Now, very specifically, the wording used is 1 calendar month, which means an English calendar month and not a specific days of 30 days, which is very commonly misinterpreted by law students and advocates. Also, by an amendment, a specific proviso was added whereby uh, a right was given to persons who are not able to file within that specific timeline of 1 month to apply for condonation of delay for initiating the proceedings. Now, for this purpose, a condonation of delay application has to be filed along with the complaint, and that condonation has to be first allowed, and then your criminal complaint will be taken on record. Now, by an amendment of 2015, subsection 2 under this provision was added, whereby the territorial jurisdiction, which was a big lacuna by the legislature, was incorporated under this act, which specifies two specific scenarios. One, where the check is deposited by the payee or the holder into his account for being encashed into the account itself. In that case, it is where the account where the payee or the holder, that is the complainant, regularly maintains his or her account, that is his home branch, and where the check gets dishonored, which is not an account payee check, which is to be encashed over the counter. In that scenario, the jurisdiction comes of the drawer's bank account where he regularly maintains his account. So, only and only these two specific scenarios are given so as to avoid confusion, because prior to this, apart from the specific scenarios given here, the courts used to interpret jurisdiction by various judgments, which has been nullified by this 2015 amendment. 142A section was brought in for this specific purpose of validation of transfer of cases because of the confusion in jurisdiction. Now, moving on to the immediate next provision, that is section 143A, which is an amended provision which is brought in on record in this specific act, which deals with the payment of interim compensation. Now, for this purpose, 143A, sorry, 143 first and then 143A, sorry. Section 143 specifically states that this proceedings under this act, under this chapter 17, has to be tried in a summary manner. Summary proceedings before the judicial magistrate will not lead to a long drawn trial, and the act itself, the provision itself specifically states that it has to be concluded as early as possible, and attempts have to be made to be conducted on a day-to-day basis with an outer time frame of 6 months. Now, moving to the immediate next provision, which is section 143A, that is interim compensation. This was brought in by an amendment for the purpose that when the proceedings are ongoing, the complainant cannot recover the amount till the final judgment is delivered. So, for that purpose, a provision was incorporated whereby up to an 20% amount of the check can be given as a compensation for the purpose of these proceedings by the accused to the complainant upon the passing of the orders by the court. Now, this section specifically states that the court in its jurisdiction may do it. It is not a shall provision, it is a may provision. The complainant can either make an application or the court by itself can pass an order specifically directing interim compensation to be paid to the complainant. When is this amount to be paid? Once the accused enters into the marks his appearance before the court, uh, records his plea, and within a time frame of 60 days that order has to be passed. Now coming to the next provision, that is section 144 regarding service of summons. Now summons are documents of the court by which the court calls upon individual persons, witnesses, documents to be brought before the court for the purpose of recording of evidence. Now sending of summons under this chapter can be done by either registered post, speed post, or courier, as may be allowed by the Court of Sessions. Now moving on to section 145. Section 145 states that the complainant or his witnesses will be allowed to record their examination in chief in the format of an affidavit, which will be brought on record instead of physically going into the witness box and orally deposing. Now this process was specifically incorporated so as to reduce the time frame in conducting the examination in chief, and so that the trial can be expedited in that manner, and specifically when there are multiple checks, multiple amounts, multiple dates to be remembered, it is important that such a documents to be brought on record along with the evidence affidavit. Now this specific section of 145 is only applicable for either the complainant examining himself as a witness or his other witnesses. This provision cannot be applied by the accused person or his defense witnesses. Now coming to the immediate next provision, that is section 146, which gives authentication to the bank slip, that is the return memo which is issued by the bank upon dishonor of the check. Now this provision says that the dishonor memo which is issued by the bank, which bears the signature, the stamp of the bank, and indicates that the check has been dishonored for whatever reason stated therein, can be held prima facie as good evidence and can be directly taken on record without specifically requiring a witness to be brought and deposing for the same. Now next provision is section 147, which explains that the offence of 138 under this chapter is a compoundable offence. Compounding of offence means where the parties to the dispute mutually arrive to a settlement and put an end to the dispute. Compounding is possible because it is a private prosecution for the purpose of recovery of amount, and there is no active state involvement in this. Hence this can be compounded mutually by the parties. Now for this purpose, the Supreme Court had laid down certain guidelines. The guidelines said that in the summons itself, it has to be mentioned expressly that the provision of compounding is available from the initial first date of the matter itself. When the accused makes his appearance before the court, he can make an application for compounding if the matter gets settled with the complainant. So in that scenario specific, the first or the second date initial part, there will be no penalty which will be involved, and the case can be settled by the parties at the initial stage itself. Then when at a later stage the parties arrive at a settlement, if it is before the magistrate court, the guideline said that a 10% amount of the check can be imposed as a cost to be paid by the accused to the district legal services authority or to any other authority. When such settlement arises between the parties at an appellate stage, that is either before the sessions court or before the high court, then 15% of the check amount is issued as a penalty, again which is to be paid either to the legal services authority or to any other authorities. Now ultimately when the matter reaches the apex court, that is the Supreme Court of India, at that stage 20% of the amount can be imposed as cost which the accused has to pay to the legal services authority or to any other authority as the court may direct. Now this staggered manner of rates was given so that the compounding can start at the initial stage itself, so that there cannot be no long drawn trials for this provision. It is important to note that when compounding happens in the court, especially when it is before the Lok Adalat, then there is full refund of court fees which is given back to the complainant, and when it is settled in Lok Adalat, there are no costs which are imposed. Lok Adalat being a public forum, a people's court as they say, the matters are amicably resolved and a settlement award is passed. Now the last provision under this chapter, section 148, which was brought in by the 2018 amendment, where it states that when the accused who's convicted has to deposit an amount of 20% before the appellate court for the purposes of preferring an appeal. Now this was with an intention of punitive nature, so that the accused at the appellate stage does not drag on with the matter, so that he understands that his conviction can be confirmed by the appellate court as well, and such amount which is deposited before the court can be withdrawn by the complainant. Now this provision, again there is a Supreme Court recent judgment of Jammu which very specifically states that it is at the discretion of the court, considering the overall circumstances prevalent in that specific case, whether to grant that 20% amount or a lesser amount or maybe even zero amount. So that is the discretion which is given to the appellate court. Now that we have completed an overview of these provisions from section 138 to 148, I would like to briefly touch on specific certain scenarios which arise when the matter is at trial stage. Now, when the complainant is a juristic person, there are a lot of times it happens that the employees who are the representatives or the directors may either leave the organization or may expire or may, for whatever reasons, may not be associated with the company anymore. In that scenario, the Honorable Supreme Court had given the ACC Cements judgment whereby the substitution of the representative can be allowed upon making an application before the appropriate court. Now, substitution is one angle, but what happens when the complainant is an individual person and he expires? Now, when the complainant as an individual expires, his legal heirs step into his shoes and can recover the amount from the accused persons after coming on record. Whereas if the accused person expires, the scenario is totally different and his legal heirs cannot be brought on record because the proceedings abet against him. The legal heirs of the accused cannot be held liable to pay the debts of the accused individual person. Now, the provision under the proceedings under 138 NI Act are of a summary nature, and the offence itself is bailable because the Act is silent upon it, and the Schedule 2 to the earlier CRPC and now BNS specifically states that when the offence is punishable less than 3 years, then such a offence becomes a bailable offence. Now, when it is a bailable offence, the accused person as a matter of right can approach the trial court, that is the Court of Judicial Magistrate First Class, and secure his bail either by furnishing sureties or PR bond or both, or may also be allowed to furnish cash surety by depositing it in the court. Now, this provision, because it is a bailable provision, the accused persons a lot of times may not even specifically appear before the court, then the complainant makes an application for issuance of warrants. Now, warrants, when they are issued, there is a judgment of the Honorable Bombay High Court which specifically states that the warrants can be cancelled by the advocate without requiring the accused to be specifically remaining present. But it, as an ideal practice, it is better to bring the accused person physically before the court and tender the application for cancellation. Further, there was also a Supreme Court judgment which said that the accused through his advocate can get his plea recorded before the court. So, this states that very specifically accused has to remain present on specific dates, and more importantly, if he is not remaining present, warrants against him can be cancelled through his advocate. His important appearance has to be there when he is furnishing surety, when he is applying for bail, and more importantly when his 313 statement is being recorded. Now, there was a Supreme Court judgment of Bir Singh where the court had held that when the accused person hands over a blank signed check to the complainant and the complainant fills the details by hand, such filling of the details and the material particulars will not amount to material alteration, and such will be valid, and the proceedings under section 138 can be launched against that specific accused. Recently, the Bombay High Court has given a judgment whereby the accused persons, for the purposes of protracting the trial and causing delays, make an application for determination of ink which was used for filling the check to be sent to the forensic science laboratory for examination, ink determination test. This is held not to be valid because as on date in India there is no provision in the forensic science laboratory, there is no technology available for the purpose of determining the age of the ink, and in this specific case the application was disallowed. Now, when it comes to the offence of dishonor of cheque, there was a notification by the Ministry of Finance for decriminalization of such offence, whereby they had asked for suggestions, but there was no final conclusion which was given to it. Moving on to the electronic age, now in 2007 there was a new act which was passed, Payment and Settlement Systems Act, where section 25 of that act is pari materia to section 138 of the Negotiable Instruments Act, and it follows the exact same procedure which I have described herein. The same code, bailable offence, same trial procedure, same kind of a punishment of either fine up to 2 years, of imprisonment up to 2 years, or fine which is twice the amount, or both. Now, this is specifically when the electronic funds get dishonored. So, that specific act provides for the definition of that and how that act can be brought into force. But it is very much like the chapter 17 of this Negotiable Instruments Act. Now, when the order of issuance of process is passed by the learned magistrate, the accused lot of times the accused generally prefer to approach the Honorable Sessions Court under revision powers to set aside the issuance of process order by the magistrate. Now, this is one of the part where they approach the appellate forum, whereas there are judgments to say that the High Court under section 482 CRPC erstwhile and now section 528 of BNS cannot invoke its inherent jurisdiction for purpose of quashing the case specifically on merits unless there are peculiar circumstances to show that it is gross abuse of process of court. It is a compoundable offence, and the High Court cannot exercise its inherent power to quash and set aside such orders. So, when we see the accused have a remedy, better to approach the Sessions Court under revisionary powers rather than going to the Honorable High Court for quashing. Now, in 2020, there was a suo motu cognizance which was taken by the Honorable Supreme Court of India, whereby there were various methods proposed for expediting the procedure and trial of Section 138, and in that there was a report which was filed by the amicus curiae therein in May 2022, which said that there are over 33 lakh cases of Section 138 Negotiable Instruments Act pending before the courts across India, not only trial courts but the appellate courts as well, and such cases are almost 30% of the entire backlog of cases across India. So, in conclusion, it is very important to understand the provisions of this Act, Section 138 to 148, and relevant provisions of the now BNS erstwhile CRPC while dealing with the trial of Section 138 Dishonour of Checks offence. Thank you to Hammurabi Tablet for giving me this opportunity, Rahul sir, Nikhil and the team. Thank you.
So Kunal, thank you very much. It was nice hearing the entire overview of the offence of 138, and I think a lot of things which you explained after your explanation of the sections, those are really the practical tips for the people, because these are the problems which people regularly faced. So thank you for that. This is a small token from us to you.
Thank you, sir.